I want to talk about a couple of things. I'm supposed to be doing some sort of overview and something. I'd like briefly to talk about the cases that my three colleagues talked about. They did, they were great. I just have a couple of other thoughts. One of them about Obergefell. I don't know any other Supreme Court opinion that I've read, I'm sure there are some, but I've never found them, that uses the word love. We've had lots of opinions on privacy and on homosexuality, and they have usually turned on sex, whether it's birth control, abortion, things like this, basically talking about sexual affairs. This opinion almost completely talks about love, and it talks about emotions, and it ends up with, and now of course I've got my papers so completely confused I can't find anything. It ends up with a paragraph from Justice Kennedy, which if I can find it I'll read, but I guess I can't, that I thought was just amazing. I think I can find it. No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people become something greater than they once were, and as some of the petitioners in these cases demonstrate, marriage embodies a love that may endure even past death. Mr. Obergefell's husband had died of Lou Gehrig's disease. It would be a misunderstanding, it would misunderstand these men and women to say they disrespect the idea of marriage. I'm skipping some. Their hope is not to be condemned to live in loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eyes of the law. The Constitution grants them that right. That just isn't what we normally hear in the Supreme Court. You can find some of it in Justice Douglas's opinion in the Connecticut birth control case where he talks about marriage, but nothing quite like this. And yet the dissenters weren't saying this is wrong. Justice Scalia says, I don't care. This is of no importance to me. Now, whether that means it's of no, he has no dog in the fight, or he thinks these people are talking about some silly thing, I don't know. He at one point says, if you think marriage is liberating, ask a hippie. I've never figured that one out, especially from a man who has been married for about 40 years. But be that as it may, what the dissenters were saying was a point that was certainly made here. Namely, this is a decision for the people to make, for the majority to make. This is what we always teach in the first week or two of con law as the counter-majoritarian dilemma. That is, should judicial review override majority rule? And immediately the dissenters, particularly Justice Roberts, went into Lochner versus New York. That's the Bakers in 1905, where the Supreme Court says it violates freedom of contract to limit somebody's work week to 60 hours a week, 60 hours a week. That's been rejected. But then the argument is, yeah, but it came back with birth control cases, with abortion, et cetera. So haven't we just started again this business of the court overruling majority rule? That's a pretty basic question. I think it ignores one point. If I asked all of you if you have somebody you care about, and let's assume everybody does, and I said, I'd like you to bring that person into this room and have everybody vote on whether you ought to care about this person, and everybody voted against you, I don't think anybody would think that that was counter-majoritarian for you to go like this. And the argument is that something as basic as the right to be with somebody else for the rest of your life shouldn't be dependent on the grace of other people. This argument, of course, was made back with school segregation with Brown versus Board of Education 60 years ago. It's a very basic question. And the current position is, well, we don't second guess legislative regulation of business, but we do when it's regulation of personal rights. And that raises all kinds of questions. Is there really a difference between those two? Or is this all one thing? And I think you're going to be seeing more and more of those questions, whether this thing overrules majority rule and whether the majority should have any say in who you marry. It's a question. I don't know I know the answer that I have, but I think it will be coming back. It's a very basic question. It's been argued for all time. Go back to Oliver Wendell Holmes' dissent 110 years ago in Lochner versus New York is the same question. Anyway, that's the beginning of the thing. That's really, I think, the big question in Obergefell that the dissenters raised, which I think is very important. My own view is, I don't think the majority should decide who you should love. People can argue that point. I'm asked, well, first of all, before we go on, I'd like to talk briefly about the Texas Attorney General's broadside of a week or two ago, because I've been asked that a lot of times. It's a lot of hogwash. And here's the point. Dan Patrick, the Lieutenant Governor, sent a letter to Ted Paxton, the Attorney General. It was one of these setup things. Would you mind telling me what we ought to do? What Paxton did was he issued a press release and an opinion of the Attorney General. Now, opinions of the State Attorney General have some importance, particularly for state officers and things like that. Exactly how binding they are, another question. But he also issued a press release. The press release was really pounding on a thing about the unconstitutionality of Obergefell and stuff like this, which had nothing, first of all, nobody cares what he thinks about the Supreme Court of the United States. He's a peon. So what's in his press release, that's fine. He can do anything he likes, and I can put out a press release, that says Ted Paxton's a blowhard, and it means exactly the same thing as Ted Paxton's press release, believe it or not, whatever you think. But he also had an opinion of the Attorney General. And people tended to confuse these things because the press release made it sound as if the religious rights of county clerks to issue marriage licenses was really in doubt, and they had tremendous protections, and it didn't say that. What he said in his Attorney General opinion was that based on the Religious Freedom Restoration Act, RFRA, which says you have to make reasonable accommodations for people's religious beliefs, if a county clerk had strong religious beliefs against issuing a marriage license to a same-sex couple, and there was somebody else available in the office to do it, he could delegate that. Well, nobody gives a damn about that. You think there's any same-sex couple who care whether the deputy clerk issues the certificate or the clerk does? But nobody noticed that. That was just a little minor thing. Doesn't mean much in a place like Harris County, which anyway, is doing it. But in some small counties, that could be very significant. There might be nobody in the office who was willing to do it. And on that, the opinion of the Attorney General says, if that happens, I don't know what the answer is, and we just have to wait and see. It's dependent on the facts of the case. So he punted. So this thing was a lot of hot air, as far as I'm concerned, because he really didn't say much. The questions of the people baking cakes and, that kind of stuff will have to get worked out. We don't have a anti-discrimination law covering sexual orientation or same-sex marriage. Don't know how it would go. If this baker is unwilling to bake a cake in an interracial marriage, I don't think there's any doubt that he has to go ahead and do it. But we have laws about racial discrimination, so it might be different. Anyway, that's a mildly important thing, I think, because everybody was saying it. What I'd really like to talk about is the so-called, the apparent drift to the liberal side of the court. there's not much doubt about where I come out in these things. Most people at this school think I'm a Marxist, except the Marxists think I'm an old lib and, not to be taken seriously. But I'm skeptical about this. I think what we're seeing here is that we got two teams, the blue team and the red team, but they're not in the Super Bowl. I mean, they're there to do justice, and I think they take that a little more seriously, maybe. I think what we're finding is the four blues, the liberals, Justice Ginsburg, now known as the notorious RBG, and Justice Kagan, Sotomayor, and Breyer have tended to vote as a bloc, while the Reds have fragmented a little bit. One member of the red side goes the other way. There are four blues ready to grab him and see what they can do with him. And some of that has worked out. We saw it, for example, obviously no Bergefell, and in King v. Burford, where you had the Chief Justice and Justice Kennedy wanting to uphold Congress. Well, the basic axiom of constitutional law is that the court, when it can, should uphold the legislature, especially Congress. That, you can argue, is what has happened in the last, in both of the big Obamacare cases. Or you can say that Chief Justice Roberts, at least, A, maybe just believes this stuff, or B, wants to protect the court, particularly back in 2012 during the presidential election, where if it had struck down Obamacare, you would have heard nothing but discussion about the Supreme Court in the presidential election. There was no discussion. The Supreme Court, he took it off the table. Chief Justices tend to be protective of the court. And it's very possible that the blue team said, hey, that's great, Chief, we're all with you. Don't know. King v. Burford, I only wanted to essentially second my colleagues. This was a badly drafted statute which raised problems. It was badly drafted. Why? First of all, it's 900 pages long. They were going all the time. There's a famous thing where some statute had an 800 number in it. It wasn't this statute, a budget statute. They were working on it all night, and somehow the statute has an 800 number in the middle of it. It turns out somebody wrote the number down on the printed copy for where to get pizza. And it is part of the United States Code. I don't know if it still is, but that's true. But on the other hand, Congress kind of got blindsided by the Supreme Court when it said the states didn't have to, they could opt out of Medicare, which of course was from 3 years ago. That in turn, I think, had a real effect on the state exchanges, which in turn triggered the Burford problem. I'll only say this. I teach legal drafting, and I'm notoriously hostile to legalese. And from the time I was in my 20s, when one of the bosses I worked for said, I see you're an anti-such guy, I dislike the word such in almost anything, since it means this or the. As far as I can tell, that's all it ever means, but it sounds impressive. In this statute, there's a reference to such exchanges. And the majority of the dissent are busy arguing what does such mean in that circumstance. Yeah, that to me makes it pretty ambiguous. Now, despite the fact that that supports the Chief Justice, the main point I'd make is anybody in this room who knows anything about drafting knows that the greatest sin a drafter can have is to write ambiguous stuff. Then it goes to court, and here's a perfect example of it. Anyway, I think that's kind of important. Now, is the court moving left? Well, we've seen Justice Kennedy, who has had a long and sympathetic history toward gay issues, and who is clearly a man of deep concern. you may remember there's a case called Casey, which is an abortion case in which Justices Souter, Kennedy, and O'Connor wrote a famous concurrence where they said, we're not really very big on Roe v. Wade. We don't think it should get overruled. Justice O'Connor spoke here at the law school some years ago, and she had breakfast with the faculty, and our colleague Michael Olivas asked her what Justice Kennedy, how he reached that decision, which I thought was a rather indelicate question, but Michael got away with it. And she said, he agonized over it. Those were his approximate words. He's a practicing Catholic. He's almost certainly against abortion. He went with it. I think that's very relevant in the gay situation. And I think the blues were there. So, you know, that's not that surprising. But what about other situations? There are others where people on the court seem to be acting in ways that the morning line wouldn't have had it. But that's always going on the assumption that the newspapers have, you know, that there really are two solid teams. There's nothing new about this. Anthony Lewis was writing about the fights between Frankfurter and Douglas and Black 60 years ago in the New York Times. And he's a great guy, but he was somewhat wrong about that kind of stuff. So what have we seen here? Justice Scalia, to the right of Attila the Hun, writes an opinion in a case called Johnson versus United States, which involves the enhancement of federal sentencing for someone who's been convicted of a violent felony. This guy got convicted of a misdemeanor drug thing in a state court, and the question was whether this is a violent felony. And Scalia, who's been fighting this thing for some years, says that is simply void for vagueness. It violates the due process clause and threw the provision in the statute out, joined by the liberals, and he got it out. But it was Scalia doing it. There's a case involving a patent issue. I don't think I'm going to spend a lot of time on a patent issue. But here, this thing actually involves Spider-Man. And it involved a Spider-Man toy that spit out some sort of thing that would be Spider-Man's web. And it got into a very technical question of patent law that I won't even go into because I barely understand it. That's been attacked and attacked and attacked for many, many years. And strangely enough, it was upheld on the grounds that Congress hasn't changed it, and we've been talking about it for many years, and Congress has not acted. That's the stare decisis doctrine. A lot of people say Congress is too busy. You know, they don't pay attention, don't put weight on that thing. But Justice Kagan does, and she's joined by Scalia and Kennedy and the other four liberals, the other three liberals. Figure that one out. The dissenters, Justice Alioto, Roberts, and Thomas, say this is nuts. This is a bad decision. Congress didn't really do anything. Why are you doing this? It sure sounds like you would have expected liberals to be saying that and conservatives to write the opinion that Elena Kagan wrote. Didn't happen that way. That's fine. There's one case that I think is a lot of fun, and that is a case called Walker versus the Sons of the Confederate Veterans. The Confederate veterans wanted to have license plates. Now, Texas sells license plates. They have more than 200. You can get a license plate for a real estate broker. You can get a license plate that has the real estate broker's name on the thing. Things like this. So they wanted that, and they wanted their logo on the thing. And the logo just happened to have a Confederate flag on the back of it. Well, so that raised some problems. Here's what it looked like. Confederate flag's over here. It's not a big Confederate flag. It's only a little one. But people complained, and in the end, the license people said, no good, we're not going to do it. They get upheld. they get upheld with the 4 liberals and Clarence Thomas voting to say, yeah, you can struck that down, and the 4 conservatives saying, what about the First Amendment? I'm going to say I think the conservatives were right on the issue, but be that as it may. So you see, we got these things going all around. Well, there are 2 things I'd like to point to, 2 orders that are kind of important here that may give us some. There are plenty of things the other way. They refused to uphold lethal a ban on lethal injections. They said the Environmental Protection Agency had to use a cost-benefit analysis, which knocked out some protective laws and so forth. But here's 2 things. They stayed the Texas abortion law, which says you can't have an abortion clinic unless you've got surgery rights, and you got, a lot of things like this, which knocked out most of the abortion clinics in the Valley and in West Texas. They put a stay on that. And there are only 4 votes. You need 5 for a stay. They got Justice Kennedy to go along. The stay is in effect while a petition for cert is pending. It's still pending. If the petition is granted, the stay will be in effect until the Supreme Court decides it. When you got 4, you only need 4 votes for a stay, and you've got 4 liberals. I mean, for a grant of certiorari is what I mean to say. You got 4 liberals. Assuming they grant cert, it means that the abortion law will be stayed at least until next June. That's pretty good. One other thing, though. The court granted cert in Fisher versus University of Texas at Austin. That's the affirmative action case, which they decided a couple of years ago. It's back, and Justice Kagan will not take part. The best the liberals can hope for is a 4-4 tie. Not likely. Anyway, there's a lot going on there. That's about all I can say.
Thank you.